Hall & Wilcox acknowledges the traditional custodians of the lands on which this podcast is recorded. We pay our respects to their elders, past and present, and to all First Nations people joining us today.
Hello and welcome to our Doing Business in Australia podcast. My name is Oliver Jankowski and I'm a partner and the head of international at Hall & Wilcox. I deal with international clients all the time and look forward to this episode in which we will be discussing the latest employment and migration law trends in Australia. I'm very pleased to have two experts here today that will provide valuable insights for our listeners. First, we have Mark Dunphy, who's a partner in our employment section. Then we have Chris Kunazigam, who's a partner and the head of our migration practice. Let's start with you, Mark. Australia has a multi-layered system of employment laws. Would you be able to explain the basics to our listeners, please?
Thanks, Oliver. Like you, I do work for many international clients in Australia who either have operations in Australia or looking to set up operations in Australia. And feedback we get from those international clients is that the Australian system of employment law and industrial relations is quite complex and multi-layered. So we often find ourselves having to give an explanation to how it all fits in. The very basics and the basic building block for the system of law we have, Oliver, is that we have the Fair Work Act, which is a piece of federal legislation that applies to all employees in Australia, irrespective of their seniority. So it applies to everybody, irrespective of whether they're a blue-collar worker, a white-collar worker, lowly paid or highly paid. The basic building blocks set out in the Fair Work Act are the National Employment Standards, which are standards that apply to every single employee in Australia, from the CEO of the largest entity through to casual temporary employees. And those national employment standards set out basics that apply to everybody, including leave entitlements with regard to annual leave. They talk about sick leave and parental leave. They talk about some basic entitlements on termination of employment and the notice periods that need to be given, and many other of the basic fundamental rights that employees have come from those NESs or National Employment Standards. The next building block, Oliver, is the award system that we have. So we have a federal award system, Australia, which are industry-based awards. And in addition to the NES entitlements an employee has, if you operate in a particular industry, for argument's sake, the building and construction industry, you will be also covered by not only the National Employment Standards, but also the Building and Construction Award, or the relevant Building and Construction Award. And that award will add to the entitlements that employees have under the National Employment Standards. So it will contain rights and obligations that are particular to that industry. So particularly when it comes, for instance, to redundancy obligations, to consultation obligations, to shifts and penalty rates need to be paid for overtime and those sorts of things, they will be covered by the award. An important thing to note, Oliver, about the awards is that if you don't need to be named as a party to the award to be covered by the award, but you will be covered by the award if you do work within the industry that the industry award applies to. It will automatically apply to you. The third layer in the multi-layered system that we have, Oliver, are enterprise agreements. And so that builds again on the National Employment Standards and the award obligations, and an enterprise agreement enables an employer and typically a union to then agree further terms and conditions that will apply to that particular workplace. So again, the award provisions that are entitled will generally be reasonably generic and general in nature. The enterprise agreement or the EA provisions really tailor them and make them work for that particular workplace. So it will extend on shifts, it will extend on penalty rates that apply. It will talk about specific sites that the employer has. Then the final building block in the multi-layered system, Oliver, are contracts of employment. And typically we recommend, because there are obligations that come from the NESs, from the awards and from enterprise agreements, we always suggest that there be a contract of employment or a letter of offer that firstly sets out what the award is that applies. Secondly, we'll talk about enterprise bargaining agreements if there are any. Thirdly, it will codify in simple and succinct words what the entitlements of the employees are under the National Employment Standards, and then it will deal with other things as well, such as confidentiality obligations, rights on termination, intellectual property rights, etc., probationary periods, and many, many other things. So, in short, Oliver, it is not just the sources of employment and industrial relations law come from many, many different places. And the best way of looking at it is as a multi-layered system with building blocks that build upon each other.
Okay, thanks, Mark. Yeah, that sounds quite complex, but it appears that it's all codified, right? There's no case law because obviously Australia being a common law jurisdiction, it's all codified in Australia now.
Well, the National Employment Standards come from legislation, come from the Fair Work Act. Then when it comes to awards and enterprise agreements, though, disputes under those agreements go to the Fair Work Commission or the Federal Court, and they'll be arbitrated on by a tribunal or by a court, and the outcomes of those decisions will become precedent for further cases down the track. So there is a body of precedent that's built up, and we need to, as good common lawyers, we need to consistently keep up with how the courts are interpreting the various provisions.
Okay, thank you. Maybe if you can answer another question or talk about a topic for our listeners around termination, because we get the question all the time, how can I terminate an existing employee? And I believe that it's in Australia quite different from some other jurisdictions. Would you be able to shed some lights on the termination rights in Australia, please?
Yeah, thanks, Oliver. Look, again, I think you've hit the nail on the head, and clients, particularly those from North America, find the rights that employees have on termination of employment here very, very broad compared to those that they particularly have in the US. Rights are generally a bit more consistent with the European way of doing things. North America and the US particularly, you'll recall, have termination for cause. You can terminate somebody at will. So employment is literally at will, and you can have been employed for a very long time, and the employer can just at the stroke of a pen decide they no longer want you to be their employee, and that employee has very, very few rights in that sort of situation. That is absolutely not the case in Australia, and American clients find that very frustrating. In Australia, employees earning under 165,000 Australian dollars have access to what's called the unfair dismissal jurisdiction of the Fair Work Commission. The way that works is that an employee will be able to contest a termination if an employer doesn't have a valid reason to terminate employment and hasn't followed a procedurally fair process. So there's a system or a process for warnings that need to be given. So an employee needs to unambiguously understand that their employment is at threat in the event that they behave in a particular way or perform to a particular standard. That there has to be a period of time that elapses to enable an employee to reach the standard that's required, and only when the employee again fails to meet the standard can the employer terminate without fear of sanction. The rights that employees have to make those an unfair dismissal claim would be to take that claim to the Fair Work Commission. The Fair Work Commission can order compensation to an employee who's been unfairly dismissed, Oliver, of up to 6 months compensation, or in some circumstances, the most blatant circumstances, they can order reinstatement. I don't have an exact percentage of the number of employees that are terminated that bring an unfair dismissal claim, but I can speak for clients where we have, carry out multiple terminations for them, and redundancies, for instance. It can be as many as sort of 1 in 10 or so, I think, that will typically bring a claim and try and agitate. There are also many other rights employees have on termination in Australia. There's a general protections regime under the Fair Work Act, Oliver, and that indicates that if an employee exercises a workplace right, so makes a complaint typically about something that's going on in their employment, or has a particular attribute such as their sex, their race, their religion, etc., and an employer takes adverse action against them because of they've either made the complaint or because of that attribute, then there'll be a breach of the general protections provisions and the employee has rights. Very differently to the unfair dismissal jurisdiction that I discussed earlier, though, damages for a general protections claim are uncapped, and we've seen some claims in that area go for many, many millions of dollars, and it's an increasing area of agitation for union-based lawyers to look at when attacking a termination. The final point I'd make on termination, Oliver, is when it comes to redundancies. I already touched upon it with regard to unfair dismissals. The redundancy provisions that are set out in the National Employment Standards and Awards and Enterprise Agreement are generally very complex, and there's a lot of common law that applies to it as well. There's a real procedure that needs to be followed, a process of consultation, obligations to look at redeployment, and we can navigate our way through those very, very easily. But the important thing to understand is that there really is a process to get through before you can go through redundancies without risk of being attacked.
Yeah, thanks, Mark. That sounds complex again. And I think what I'm hearing is before an employer terminates one or several employees, they should definitely seek advice to minimize the risk of any claims being brought by the employee.
Yeah, it's significantly easier for us to defend a claim, typically, Oliver, if we've been involved prior to the termination taking place and been able to put a process in place that bears in mind that the employee will have rights to the unfair dismissal jurisdiction and will have rights under the general protections regime. So it's increasingly common for employers to seek advice before they move to terminate somebody's employment in Australia.
Okay, thanks, Mark. And Chris, I might ask you, when we're talking about termination of employment, there are certain visa classes in Australia where the employer sponsors an employee for their visa. So if one of those employees gets terminated, what happens with the visa, Chris?
Yeah, thanks for that, Ollie. And it's certainly something we're increasingly seeing happen these days. I think with interest rates the way they are at the moment and spending of companies not necessarily being as robust as what they were a couple of years ago, we're seeing this issue prop up more often. To set the scene, about 1/3 of people residing in Australia are born overseas, so 1 out of 3 born overseas. And so when that
like you
ratio,
and
yeah, like you and I, correct. And when that ratio is that high, it also means the natural progression of someone coming out here is they come initially over on some form of a temporary visa, and then they transition to a permanent visa. It's the transition to the permanent visa, which is not so much of an issue from an employment perspective, because once you have permanent residency status or as the North Americans would refer to it, green card status, it's not really an issue. So if you, quite frankly, are made redundant or lose your job, you can still remain here. The issue always arises when someone's on some form of a temporary visa. So it usually means, say, if an employer sponsors you and all of a sudden your role is no longer ongoing, there are conditions on your visa which says you have to depart the country or find a new employer within a set period of time. Now, right now, that is 60 calendar days. So if your employment ends, you've got 60 days to find a new employer. If not, the expectation is you depart the country. There are, though, changes being proposed by end of year where they plan on extending that stay period to 6 months. It's on the back of a lot of public resent against, someone who's not in a position where they were sort of forced to leave that position, their job, and then forced to leave the country 2 months after. We all know sometimes finding a job can take a bit longer than that. So the federal government now is proposing on increasing that up to 6 months. And we'll know for certain by end of year whether that happens, but that's the proposal.
Okay, thank you. Very interesting. Mark, I might ask you another question around restraints of trade, because I'm aware that particularly in Europe, some countries are trying to limit the enforceability of restraints of trade, particularly for sort of non-key staff like CEO and so on and so forth. What's the position in Australia? Are we going down that same way?
Yeah, not yet, Oliver, but as typically happens, I suspect that we will end up following the trends that are being instigated in Europe and North America at the moment, in that restraints of trade will almost be outlawed. There is certainly the beginnings of noise from some political parties to want to go down that track. At the moment, though, the status quo is, well, there are two status quos in Australia with regard to restraints. There's a situation in New South Wales, and then there's a situation in the rest of Australia. Effectively, restraints will be unenforceable unless they're reasonable in the circumstances. So we end up doing a lot of work in the restraint of trade space. And the problem that most employers have is that they try and bite off more than they can properly chew. So they go and the restraints will be unenforceable because they're unreasonable in the circumstances. So in our view, the best restraints of trade clause really individually turn their mind to what the employee is doing, what the employer does, and look at what the employer's protectable rights truly are and what damage the employee can cause to them, rather than just simply saying that the employee can't operate in the same industry across Australia, for instance. Now, that would be typically unenforceable if the employer doesn't have operations across the whole of Australia. So, in other words, Oliver, I think at the status quo at the moment in both New South Wales and in other states, and the distinction is in New South Wales as a particular piece of legislation that applies, that doesn't apply in the rest of Australia, but the status quo is that a well-drafted restraint of trade clause will be upheld by the courts, and there is, however, a movement in the background toward that being outlawed, but I think we're still a fair way from that being the case yet.
Okay, thank you. Interesting. So still being able to enter into new contracts with those restraint of trade clauses, and they will be enforceable at least for now. Okay. I might ask you a last question about sexual harassment cases in Australia. I believe that there have been some changes or some trends that you could talk about.
Yeah, thank you. Look, there are absolutely, Oliver, like the rest of the Western world, things in the sexual harassment space have changed very, very significantly over the last 20 years or so. Sexual harassment cases used to be looked at as minor cases in the workplace, which weren't really treated seriously and certainly didn't attract significant awards of damages if they're litigated. That is absolutely not the case now. Sexual harassment cases are looked at as in the category of the most serious of cases you can have, or issues you can have arising in the workplace. Occupational health and safety laws have been bolstered to give regulators significant ability to come into workplaces to investigate sexual harassment and other issues. And there's been a whole raft of new legislation and regulation around psychosocial hazards, of which sexual harassment and sexual innuendo certainly form a significant part. So it's really the front and centre of everybody's attention now, sexual harassment. And for the cases that do get to court, the awards of damages have increased many fold. What was looked at 20 years ago as a nuisance value claim could now, it's not uncommon to see judgments going into the many hundreds of thousands of dollars, if not millions of dollars, for those cases. So it's an area of great consciousness for employers in Australia, and end up with those significant claims against them in that area at their peril, Oliver.
Thank you, Mark. That's helpful. Chris, I might ask you the next question. Migration to Australia, it's a very topic in Australia that's often in the headlines. It's political. It's all around, what's the right number of people that can come to Australia.
Right.
Every year. I know that I think last financial year was a record number of people that came to Australia. It is growing strongly. But can you give us the latest, please? Do you think this year will it generally become easier or more difficult to obtain a visa to come to Australia?
That's a good question, Ollie. Thanks for that. The answer is yes to both those questions. So it's easier in certain categories. It's more difficult in certain categories. So like the rest of the world, I think Canada in particular as well, Australia has on the ground a similar issue where there are insufficient affordable housing for many of the local residents, and that's sort of become a political issue out here where it's linked to newly arriving migrants into the country, taking up spaces or just not having enough housing available. And so it's pushed up the cost of living because of that. That then leads into the political landscape out here. So it then affects the migration planning numbers. So long story short, there are too many people coming. There are not enough houses. We need to slow it down. That's the political message for 2024, 2025. Which categories are being targeted? Well, it's largely the student visa cohort. So we've sat in numerous meetings over the last couple of weeks within the education sector itself, where student numbers are dropping, and also staff linked within that industry itself are having their jobs being either made redundant or being retrenched because there's just a drop in the number of international students coming out here. So we expect the student numbers to drop over the next couple of years. There's no published timing yet in terms of the numbers and when that will happen, but we're definitely seeing an increase in terms of the refusal rates out here. So the international student cohort will drop. But at the same time, the government realizes it needs skilled workers to do roles. So certain roles, highly skilled, the government's invested into STEM-based occupations, science, technology, education, math. That's sort of their main focus on innovation and growth. And so the lead-on effect for that is anyone who comes over on one of these employer-based visas, those ones are still in demand. They'll still continue processing those visas. And in fact, they're making it slightly easier for people to obtain those visas. For example, one of the key requirements before was a person needs to prove they have 2 years work experience to qualify for one of these visas. From end of year, they're going to reduce that down to a year's worth of work experience only. So only 1 year. Now, that would mean the pool of candidates who would then qualify for these kind of visas, these work visas, will significantly increase. And where we see that benefit flowing through is industries where there's a really short supply of workers. And that's largely in the healthcare sector, childcare sector, aged care, and education. And these are clients who we help daily. And they don't have enough people, but at the same time, they have people who don't quite yet have that 2 years experience. So it's a bit of a gap. So I think what the government's proposal with the changes at the end of the year, it's going to be beneficial for those industries.
Thank you. Really interesting. And I mean, you alluded to it just then, but maybe I can ask you to clarify that a little bit, because you hear in Australia all the time that there are skill shortages, right? That employers really struggle to fill certain positions. Can you say a little bit more about that? What the industries are, other than the healthcare, aged care, and so on and so forth, that see skill shortages? Hairdressers, I've heard. Is that true?
Yeah, hairdressers used to be a theme, I would say maybe about 8 years ago. That was a big in-demand occupation, not so much these days. Childcare is a big one. Childcare, what we've been hearing is a lot of the workers in the childcare sector have abandoned that sector because the government has introduced subsidies to the aged care sector. So basically, you earn more if you were to do aged care work. And so a lot of the workers in those roles have jumped industries from from child to aged care sector. So that's a real short supply. Another big industry is, like I mentioned, the teaching industry. So because of COVID, there was just a drop in the number of fresh graduates hitting the market with a teaching degree. And at the same time, a lot of the existing teachers just decided to resign or just retire early. And so there was a big gap, if you can imagine, between the existing pool of teachers available who then choose to retire early, and then at the same time, a gap in the number of graduates having to fill in that role. There was just, because to obtain your teaching degree, you have to do a placement. Because of COVID, placements didn't happen, and so people couldn't finish off their degrees, and so there was this massive gap. And so it's led on now to a shortage of teachers in Australia, and it's more apparent in regional or sort of rural cities where it's a smaller population. They're really struggling to get teachers out here. And so we've been assisting with that process where we would team up with a recruitment company to get a teacher from overseas to bring them out here to place them into these different regional towns. A new potential area which we're also seeing is the defense industry. I think with a lot of spending and the upgrade in the military spending in Australia, we're noticing a lot more experts are required. I mean, we're speaking about engineers, project managers, specialists within the defense industry who are in deep demand in Australia, because we just don't have that many people out here with those skill sets. So we're noticing a lot of our European and North American based clients set up and send people out here to support that industry as well. So yeah, I think over the next 12 months or so, we'll see this sort of three key industries pick up on top of the existing healthcare and IT-based clients. That's always going to be there, but these are sort of the three industries I foresee just having a massive growth over the next 12 months.
Okay, terrific. Thank you. We could talk about those topics all day, but that was really helpful. Thank you to both of you, Mark and Christopher. And to our listeners, thanks for listening to today's episode. If you have any questions, please feel free to get in touch with us. You can find our details on our website, or you can connect with us on LinkedIn. If you enjoyed today's episode, please rate, review, and follow our podcast wherever you listen to podcasts. Thank you.
This podcast is not legal advice and should not be relied upon as such. You should always obtain legal advice about your specific circumstances.